Hello, I'm Justin M. Kennedy, an attorney with Little Kennedy and Associates, a California estate planning and elder care law firm. Today, I'm going to discuss the 2022 updated California probate thresholds. As an estate planning attorney, I help many clients to avoid the costly and time-consuming court death probate. This video is not going to focus on the negative aspects of probate, but instead it will focus on the dollar value thresholds that trigger probate if the asset is not held in a trust or does not have a death beneficiary designation, or if there is no surviving joint tenant owner. As of April 1st, 2022, the general probate threshold in California was increased to $184,500. This is the threshold that most think of when they are wondering if the assets need to be probated. With a probate threshold of $184,500, if you pass away with only one bank account and that bank account holds $185,000 and the account is not in a trust, it does not have a pay on death or transfer on death beneficiary designation, and there is no surviving owner on the account, then that account will need to be probated. What if you have two accounts, each holding $100,000? Let's assume that neither account is in a trust and there is no beneficiary or joint owner. Then even though each account by itself is less than $184,500, because the combined value of both accounts exceeds the $184,500 probate threshold, both of these accounts will need to pass through the death probate. In addition to the $184,500 probate threshold, there are several other probate thresholds that were also updated as of April 1st, 2022. Let's review those here. If a decedent had a surviving spouse or minor children and an estate exceeding $95,325, then probate may be needed as the small estate set aside would not be available. If the decedent had salary or compensation due to them of more than $18,450, then that salary would need to be probated. Finally, if the decedent owned real property in the state of California that was not held in a trust and there is no surviving joint tenant owner, then that property would need to be probated if its value exceeds $61,500. As almost all real property in the state of California will exceed the $61,500 threshold, that means if the real property is located in California and is not held in a trust, then it would likely trigger probate upon death. This is why it is so important to work with an experienced estate planning attorney who can help guide you through these steps of creating a living trust estate plan and explain the process and importance of funding the assets into that living trust in order to avoid the costly and time-consuming court death probate. Thank you.